Good morning, ladies and gentlemen, boys and girls. A very warm welcome to all of you to the second day of Tech 2018. I hope you had a good time yesterday and are all excited and energized to enjoy another great day of some good sessions. So without further ado, I welcome our first keynote speaker for the day, Jeffery Morrison. Jeffery Morrison is a US international lawyer and managing director of the Brexit Legal Network Limited. He has graduated from the Harvard Law School and is a member of the bar in California and New York. He has more than 45 years of experience in US international litigation matters and tax disputes and has dealt with the Swiss bank secrecy matters, RICO and high-profile cases of white-collar crime. He has also worked as an independent consultant with Evershed Sutherland and published extensively on legal, scientific, commercial, industrial, linguistic, and historical subjects. Ladies and gentlemen, with a huge round of applause, let's welcome our first keynote speaker for the day, Jeffery Morrison. He will be talking on artificial intelligence in education, who owns and who manages. Have a good time. Can I adjust the screen?
Thank you. Well, good morning, and thank you very much for that exuberant and slightly embarrassingly exaggerated introduction. I hope that what I have to say here will somewhat live up to the billing. Here's what I'm going to do. I'm going to restate the theme and my predictions about it. I'm going to talk quickly about some terms and conditions. I'm going to then invite you to a 9-point interactive learning experience with me on how to become an international IP lawyer in 5 minutes. Then I'm going to open up questions and answers, and then I will sum up in a couple of words. So, number one, the theme and my predictions. The theme is artificial intelligence in education, who owns and who manages. Here's what my conclusions are, and this will be supported in a paper that I will submit to the conference organizers when I get back to England. My general conclusions are that US law will resist granting broad intellectual property protections such as copyright, patent, trademark, and trade secrets to output created by artificial intelligence in the edutech field, and that the well-established legal doctrines of fair use and first sale will play important roles in tempering the concentration of monopoly commercial power, to which must be added the creative use of individual US state laws regarding property, contract, privacy, consent, agency, and employment. If US history is a guide, the rules of the game will be worked out by a combination of industry competition, government intervention, ongoing consultative action by and among various stakeholders such as academia, teachers, students, institutions, and transnational bodies such as the UN, plus alternatives offered by free data groups, as well as ultimate determinative adjudications by the courts, principally for the USA in the Supreme Court of the United States as regards federal law. Okay, that's enough of that. That's the technical stuff. There will be no more of that. Next, the terms and conditions. This is more the real world. I asked the colleagues at the conference organizing staff to help me find examples of terms and conditions at websites in India where online educational services are offered. In other words, real-life situation. You're a student, you're a teacher, you're a parent, you go online to a website in India that is offering educational services. And there will be, somewhere in there, terms and conditions or terms of use or privacy policy. I would imagine that not many people click and then go and read those terms, and if they do, here's the type of thing that's waiting for them. And these have not been selected by me to prove a point. This is the way the world works, especially from the perspective of a California lawyer. Here is a set of terms and conditions of a company called Coursera, which I believe is known to you here. I've printed these out. There are 11 pages of what's called legalese. And here's what it says on page 5, if anybody gets that far. I'll just read this one part. And let's just see how this grabs you. This is just on page 5. The services are managed by Coursera, which is located in Santa Clara County, California. You agree that any dispute related to these terms will be governed by the laws of the state of California, excluding its conflict of law provisions. You further consent to the personal jurisdiction of and exclusive venue in the federal and state courts located in Santa Clara County, California, as to the legal forum for any such dispute. So what you've just agreed, if there's any dispute, you have to go to California and fight about it. You know, good luck. There's another one from an organization called Guru, GOORU.org, which I presume you're familiar with. But it's an Indian offering. This one is 13 pages. And on page 11, it also says that it's governed by California law, but it says it in a slightly different way. You literally have to be a lawyer to understand what this stuff means. Next point, which I tried to make in my panel, you do not have to consent to these things. You do not have to be treated to what's called in America a contract of adhesion. In other words, take it or leave it. One of these also compels you to arbitrate in California if they wish you to. So these are binding under California law. I'm not going to criticize either of these companies for attempting to pursue their commercial interests, but these are serious matters involving legal consequences. But the same is true for you. You have intellectual property that you already own or will create that they want, and your data and your input is more valuable to them than anything they can give you in return. Next point. If I can just find my notes here. The learning experience. This will not be like law school. Law school is not very pleasant, but here's my example of a quick law school course. I'm going to read 9 questions to you, and I'm going to ask you to think about them. Who should own the intellectual property in? That will be the theme for every question. Who should own the intellectual property in a photograph taken by chemical or digital means? Number 2, who should own the intellectual property in a photograph taken by a monkey trained by a human being? 3, who should own the intellectual property in a discovery made by a human during a dream or a trance? Number 4, who should own the intellectual property in a paper perforated strip which allows a machine to play music which otherwise is only on paper in musical notation, like a piece of paper? Number 5, who should own the intellectual property in something that has been jointly created by a human and artificial intelligence interaction? Number 6, who should own a pharmaceutical made from your blood sample when you go in for a standard test and consent to your blood being used for the test, and instead your DNA is used to create a medical product that earns billions of dollars? Number 7, Who should own the intellectual property created only by artificial intelligence that has first been set in motion by a human being? Number 8, who should own the intellectual property in data that you input with the blinking of your eyes and the clicking of your mouse and your selection of words to read or use in what you think are your private communications? Who should own that intellectual property? And finally, number 9, and there could be 1,000 of these, but this is a short session, and I'm already halfway through. Who should own the intellectual property in a situation where a university or academic institution provides a laboratory, a salary, equipment, research funding, and that leads to the invention or discovery of something of great value, either in human terms or monetary terms? Those are the questions. I'd like you to think about them. But now let me put them into some type of a legal context. Intellectual property is protected in a number of ways in the law. Copyrights and patents, trade secrets and trademarks, and also by means of contract, agency, and employment laws, as well as by governmental regulation. Let's go down those very, very quickly, and please be thinking of those 9 questions. Copyright is a legal protection of intellectual property that is based upon original creations by human beings. And the duration of that protection is monopolistic. If you have a copyright, you have a legal monopoly, oftentimes for as long as 100 years. The general rule in the world is 70 years after death. The U.S. rules are more complicated because the U.S. has only recently adopted that more common rule. So you can say that 100 years is a good average for that legal monopoly. Pretty long time. Patents also give you a legal monopoly, and they must be based upon an invention that is new, useful, and non-obvious. There, the length of time for your legal monopoly is not as long as 100 years. It's 20 years, but in practical terms, it may be shorter. Trade secrets, as the name implies, are something that is a secret. It's not the subject of a patent or a copyright. The recipe for Coca-Cola, no one has yet figured that out. It's a trade secret. The legal monopoly there lasts forever. The same is true of trademarks. If you have a proper trademark and treat it properly, then the protection of your monopoly can be forever. And then we come to contract, agency, employment, and regulation. All of these different mechanisms operate together, and there's a lot of history in the United States about how these operate together. And so now let's go back to our 9 questions. We have 8 minutes left, so we're right on time. I'll give you the answers to the questions, and then please be thinking about them. Who should own the copyright in a photograph taken by chemical or digital means? No human intervention. Who should own the copyright? Well, perhaps. I'll give you the answer. This is a very famous U.S. Supreme Court case in 1884. These are old issues. People were smart then, too, and they wanted to fight the right answer. You probably have seen, it's a very famous photograph of Oscar Wilde. He made his famous visit to New York, and he's sitting with his flowing hair, and he's sitting with his silk pantaloons or breeches. Very famous photograph. And it was prepared by a photographer called Mr. Saroni, and somebody saw it and said, I'll buy 1 copy of those, and I'll turn it into a lithograph. And the lithograph became very, very successful and made a great deal of money, and the lawsuit was about who owned the copyright. In that case, the argument was that the photograph had been made primarily 99% by chemical means. It's a lens, it's silver nitrate or whatever is involved. It's light. Nothing to do with Mr. Cerrone. It's not like sitting down and writing Beethoven's Fifth Symphony. But Mr. Cerrone won the case. The photograph copyright belongs to the person who has arranged the work of art. The way Oscar Wilde was sitting, the way the lighting fell upon him, that was considered a sufficient act of human creation for the Supreme Court to affirm that monopoly. Next one, photograph taken by a monkey trained by a human. Sounds very silly, but it's the same concept. And that was the subject of a Ninth Circuit Court of Appeals decision in April of this year, in which the federal courts in California had to decide whether a selfie taken by a macaque monkey owned by a British photographer was subject to the monopoly granted by copyright. Rather than dismiss this as something very silly, it's not silly. It's the same concept. The monkey was given legal status to bring the lawsuit, must have, otherwise there wouldn't be a lawsuit, but the court decided that under those circumstances there was not enough human intervention. Number 3, discovery made by a human during a dream. The chemists in the audience will know about Mr. Kekule, who was reading a book about the Ouroboros, the snake that bites its own tail, and he went to bed that night, and during that dream he figured out the benzene ring. So who owns the discovery made by a human during a dream? Well, all I can tell you in the time available, which is a few minutes, is the U.S. Copyright Office has detailed guidelines as to what can be copyrighted. We're talking copyright, not patents. And it says, the office may register a work where the application or the deposit copyright copies note that the work was inspired by a divine spirit. It's from the official copyright. So there is ample room there to make legal arguments. Number 4, paper strip, which can play copyrighted sheet music. You have a sheet music, perceptible by the human eye. You don't hear the music unless you could read music. Strip of paper, it could be like the Jacquard punched cards, it's the same idea. It plays the music. Very difficult case for the Supreme Court of the United States in 1907. How should that case be decided? How much intervention was there? You have the copyright of the music, which is protected, and someone comes along and simply buys one copy of the sheet music, turns it into holes in a sheet of paper that plays pianos. And since there are many, many more people that can listen to a piano than can read sheet music, guess which one made the money? Right, the player pianos. So who should win that case under copyright law? Any guesses? Be the Supreme Court of the United States in 1907. How would you decide the case? The music composer. You want it to be the music composer, don't you? Because you feel that's morally right. Well, be disappointed. But that's the reason I've chosen this example. You sense that the correct moral conclusion is for the composer to win. But Congress then in 1909 fixed it. They changed the law. So that's regulation in my list. Next one. Intellectual property created jointly by a human and artificial intelligence interaction. Answer to that, we don't know yet. Number 6, the blood case. Mr. Moore was a patient in California. He gave a blood sample. He gave consent. You may use my blood. They used his blood for his purposes, but they went on and they developed a pharmaceutical based upon his unique DNA configurations, and they produced a pharmaceutical product that earned $3 billion, and they paid Mr. Moore nothing. So there again, Sandra, I'm sure, will feel that morally he should be like the composer. Well, he lost. And he lost in California, which is a liberal state. So the theme here is it's difficult. So Mr. Moore, his personal data was used, and he gave consent. But he didn't give consent to that. But consent is a dangerous thing. It can have consequences that you have to think about very, very carefully. So when you sign a term of use, and it says these things you don't understand, beware. Next, intellectual property created solely by artificial intelligence interaction set in motion only by a human being. So it's a little bit like the camera case. It's a little bit like the piano case. Number 7, we don't know yet. Next, who owns the intellectual property, or should own the intellectual property in the data gathered by those eye contacts and those word selections when you go on a website and it is tracking them and running them through an algorithm and comparing it to millions of other people. Who should own that? We don't know yet. And number 9, famous case decided recently by the US Supreme Court, this is the academic research situation. In this case, it was Stanford University. They provided the laboratory, they provided the money, and someone found something very valuable. Who should win the case? The lonely scientist dealing with the mysteries of the universe, or the great big pharmaceutical company, Hoffmann-La Roche, which developed the pharmaceutical, or should it be Stanford University? The Supreme Court decided. How do you want the case to be decided? Sandra, morally. All right?
The university? No, I mean the guy who, the scientific.
Welcome to the Supreme Court of the United States. That is the same answer that was decided by the US Supreme Court. So, there is a logic, there is morality, there are difficult issues. We can do it together. And so my final question, my final admonition, I've got 2 seconds left, is be like Mr. Kekule. Be like the macaque monkey that took selfies. Go out with your dreams. The law will be there to support you and protect you, and usually it will get the moral answer. But don't sign things you don't understand. So I think there's a minute for questions and answers. I can't believe I've answered all your questions. That would not be good. Well, if there are no questions,
yes,
then
there
I'll...
is a question. Mr. Moran, I have a group of 8th graders sitting here. They came from a school nearby, and they have to provide a report back to the class. Can you sum up 2-3 points they took back home to their teachers and other students?
Well, if they can wait until my paper is online, I think
No, right now and here, because they're going back tomorrow and they have report duties, and I try to explain to them.
I can sum it up. That
it's for you. Pay attention.
the data that you create, whether it's for your report or whether it's in your classroom or whether it's talks with your parents or your schoolmates who may be in Australia or who may be in Canada, that is important data input that belongs to you. And you should not underestimate its commercial value or its social value. Remembering that the conference topic is education for humanity. And so be thinking of the moral uses of what you discover and what's of interest to you. And usually the law will support you, but don't give it away. Don't consent without understanding what you're doing.
Okay, I've got it.
Anything else?
I've
Well, then I'll give up the floor then to someone else, and I'm, of course,
one more question. I've got one question.
Yes.
At the end, there are 2 or 3 questions that you said haven't been answered yet. And you also said there were good moral, logical answers that would that have been given to these questions in the past. So I want you to give the good, moral, correct answer to the 2 or 3 questions you didn't answer.
Well, I think that one of them was who should own the intellectual property in novelties that are created by human and AI interaction.
Right, that's a really important question. So you tell us what you think the proper answer to that should be.
I think that the emphasis should be in favor of the creative human being. And that also happens to be, thank you. Don't applaud me. From America, although I appreciate it, the founders of the U.S. nation in 1787 and 1788, they thought and worried about this issue, and they were very, very clear that it is the individual human being who should win. And that's why some of these cases have been decided by the U.S. Supreme Court in that way. It's the,
There's a slight problem because the creator of the artificial intelligence is also an active creative agent. And the problem is you've got multiple social agents who are in a collaborative relationship that decide in favour of one over another, when in fact it's a social construction. The business of dividing ownership is in itself a problem.
yes, I know, and I can refer you later on to a particular U.S. case in which the Court of Appeals went into a three-part test to deal with this. It doesn't resolve all the issues, but it's referred to in my paper. I believe the human should win and the human will win, that you need good advocacy, you have to be careful of consent, and you have to know what your rights are and be diligent in asking about them. And then the other one was what should be the ownership of intellectual property that is allegedly created solely by artificial intelligence. My answer to that is there ain't no such animal. It's always going to be humans, I hope. Thank you very much. Okay?
Thank you, Jeffrey. Those are some really interesting questions on intellectual properties and the copyrights, and I'm glad we could answer some of them. Now we move ahead to the next keynote speaker for the day, Dan Schaffer. He's a lawyer at the Paris Court of Appeal, France, and an expert with the Council of Europe on the Internet Ombudsman. He's also an honorary member of the European Lawyers Union and an individual specialist to UNESCO. In 2014, he founded the Association for Accountability and Internet Democracy, whose main objective is to introduce a general principle of accountability on the Internet. Dan is also a frequent speaker at international conferences and academic venues on IT law, data privacy, content regulation, and human rights on the Internet. With a huge round of applause, ladies and gentlemen, let's welcome Dan Schaffer. He will be talking on the essential skill.
Hear me? Yeah, now it works. Thank you, everybody, for getting up here in the middle of the night. That's really, I'm really delighted. And Jeffrey, that was a very, very interesting presentation. Don't worry, I won't talk too much law, but there will be a few points, and one of them is going to be pure law. I had a problem deciding what subject I really wanted to talk about today, because this whole conference being about technology and about humanism and education is so vast that whenever I found a subject, I changed my mind and found another one that was even better. Until one day, I was actually on vacation, it occurred to me that I understood what the real problem was, what the real challenge was that we are facing today in terms of education, humanity, and technology. But before getting to that, which I call the essential skill, just try and answer the following question. What I have right now is something that's worth billions of dollars, something that corporations are fighting for every second round the clock. And what is that? What do I have right now which is worth billions of dollars? Your attention. I have your attention. So what I'm going to ask you, please, is to focus and concentrate that attention. I know it's going to be hard. Put away your phones. Get back in the driver's seat. Be in control. Let us decide where our attention goes. Now, the reason I mention that is that that's so key for education. Now, before I get to what happened when I was on vacation and understood what the real problem is, let me tell you another story inside the story. You know, building it up, right? Lawrence, I'm glad you're here. Stand up, everybody can see Lawrence. Our friend from Germany. Hello, Lawrence. As you can tell, Lawrence didn't know I was going to pull this trick on him. And Lawrence and I, we didn't know each other, but we met in Delhi. And we flew together from Delhi to this place. And Lawrence was my victim for 2 hours, right? You sat next to me and you pretended to enjoy it. So that was lovely. That was lovely. At a certain point in time, Lawrence dozes off, which gives me the opportunity to look at this lovely seat pocket in front of me, and I found this newspaper. And there was this incredible story about a Japanese man called Okihoto Kondo. Do you know who that is? Okihoto Kondo. You know what he did? He got married. Now, what's so strange about that? Why was that in the newspapers? He got married to a hologram. What? He got married to a hologram. This guy invited 40 people to his wedding. It cost him $17,500, or the equivalent in yen, and he got married to a hologram. 35 years old. And he loves it, or her, or whatever. You know, what is this universe we're creating? So I started understanding what the real problem is. When I was on vacation, it was in the south of France, in Cannes, lovely place. And so I went to the beach every day, about 10 days or something like that. And there was this girl on the beach, 2.5 years old. She wasn't playing in the sand. She wasn't swimming. She was sitting there on the beach, playing with her phone, right? Her phone, not her mother's phone, her phone. 2.5 years old. I suddenly understood what the problem was. Bang. Okay. Are we on? Here she is. Isn't she lovely? Her name is Maya. Now you see, this was not a sunny day, so she wasn't on the beach that day. She was cycling. But she's got her phone in her hand. 2.5 years old. What is the universe of Maya going to be when she's 10, when she's 15, when she's 18? With people marrying holograms? I mean, what is the world that we're creating for Maya? What are her values going to be? How will she get her knowledge? How will she get her information? Will she get it from school, or will she get it from this thing that's with her all the time? Or whatever it will be in 2 years, 3 years, 4 years, and 5 years. Well, I'm afraid, I'm seriously afraid, that everything she will know will be what this thing tells her. And her attention, well, you know, I'll get to the book. Her attention will be captured by this. And in reality, she won't know very much, because whenever she wants to, you know, whenever she's thinking of something or she wants to check something and so on and so forth, she'll just look it up. She won't have to remember anything, right? She just looks it up. And speaking about books, why should she learn to read? Why? She can just talk to this thing, right? Is it really necessary that she learns to read and write? You think it is, but I challenge you, maybe it's not. Sorry, we'll get to Q&A. I really don't think that it will be a necessary skill for her in this environment to learn to read and write. And certainly doing math or counting won't be necessary. She'll just ask this machine to do it for her. And all the information that she'll get it immediately. She doesn't need to remember anything. That, dear friends, that's the challenge. That is the problem. 2.5 years ago, I helped a senator in France draft the first law in Europe on fake news. I'm so glad it didn't pass, by the way. but it was a really interesting exercise. Now, the first recital of that law was that we need, as you say in French, to make it a grande cause nationale, right, which is the big national cause of education. And that was probably the only part of the law that I would have liked to see passed. How many teachers do we have in the room? Educators? I thought so. I thought so. Okay. You're in the forefront. I mean, you are really the soldiers protecting our humanity. You really are. And our civilization. Your job will not so much be to teach reading and writing and math and the rest of it, but teaching our children, and I'm going to use another French word, which is the esprit critique. You need to make sure that our children question everything and don't have their lives and their universe dictated by this thing. Your job is to teach our children to be independent, to be autonomous, and to think and to question everything. Now, as a lawyer, it's interesting that one of the things that you learn in the courtroom and also when you have discussions and so on is there is an art which seems to be completely forgotten in education. Completely forgotten. And to me, it's the most important. And it should take place at first grade level. And that's the art of debating, right? The art of debating, forcing Maya, to argue the opposite of what this machine tells her, just for the sake of the argument. Forcing everybody in the classroom to see the other side and to argue against themselves. If we teach our children to do that, it's going to be more important than reading, writing, and math, because again, they're not going to use those skills. We need to teach them that the true meaning of relativity. We need to teach them that whatever the truth is, and I'm not going to, this could be a 3-day thing, it's most probably not what they get from this machine. There's a really interesting story about Wikipedia, right? That's where we all get our knowledge from, quote unquote, today. And look it up afterwards. It's on Wikipedia. It's called Wikipedia Hoaxes, right? So these are unmasked stories on Wikipedia, scams, hoaxes. Some of them go unchallenged for years. The latest statistic I read on this is that one third of all Wikipedia disputes are left unresolved, all right? The idea of this universal encyclopedia doesn't work. Yet it is the source of wisdom. The source of wisdom for much of us in this room, and certainly it's going to be for Maya. We need you, teachers, you need to make sure that our children, and I hope you will question everything, will be irritating. That's what you need our children to be. They must be irritating, question everything, especially since otherwise they'll be completely manipulated by the thing. So my first point was really the importance of debate and the importance of not getting information from this kind of thing, but making sure to stop disinformation. I promised to make one legal point. I got to say that when you talked about the cost-benefit analysis, and I agree, you mentioned that yesterday, everything sooner or later translates into ethics and law, so the points I just made now are also legal, but not in the strict sense of the word. But I've got one legal question here is, the corporations that will determine the view of the universe, the cosmology, the epistemology, right, of Maya, what are their obligations? Now just I used the word epistemology, right? The science of knowledge. Today, knowledge is reduced to correlations, right? Big data is correlations. If this happens, then there is a probability then that will happen, all right? And we think that we know more because of that. Of course we don't. The world is much more than probability and statistics. The world is really, if we want to understand it, if we want to get back to cosmology, it's not correlation, it's causality, right? You remember that? The word causality? It doesn't exist any longer in science. Everything is probability. And the problem is that probability often works, but it doesn't give us an understanding of how the world works. We need to get back to understanding the basics, the basic importance of causality, cosmology, epistemology, and not just get information that with certain probability may be true or not true. So what is the responsibility of the corporations that will, and I use the word here consciously, manipulate Maya when she grows up? And again, this is Maya today. Who knows what her universe is going to be like when she's 10, 15, 18, and so on and so forth. I don't know whether I'd be particularly fond of being part of that thing, but I probably have to. You could ask yourself, from a legal point of view again, what is the responsibility of the Wikipedias today and their equivalent in a couple of years? And the companies that produce the games that we heard about, fascinating games, by the way, and all the other companies that do e-learning and either license it to schools or give it for free. By the way, as we all know, nothing is free, right? What is their responsibility? Now, I mentioned yesterday with Artie that I did not download the lab for this conference. Actually, I should have, because it would have been much easier to know, what was going on and when I was going to speak and stuff like that. But I didn't. And I didn't do it because I simply stopped downloading apps. I personally did it because I had this case a couple of years ago. You all have flashlights on your phone, right? Right? Most phones are, equipped with the default flashlight, but you can also download flashlights from either Google Store or from App Store or whatever. And I had this client who had downloaded this flashlight and found out later that it included spyware, right? As I said before, nothing is free. And the case was pretty complicated because the flashlight app was developed in Ukraine. It was then put on one of the big platforms that I mentioned before by a company based in Seattle. And it was distributed in France through Vodafone and SFR. Pretty complicated case. Who was really responsible for the malware that was introduced on everyone's phone here in the case I just described? Very complicated. Now, needless to say, this is the kind of case that is settled out of court. So if you're sitting there waiting to get the answer, we could discuss what it should have been, what it shouldn't have been, and so on and so forth, but this particular case was settled out of court. The point is that if you produce something in the physical universe, right? A car, that's the typical example, thanks to the consumer movement, especially Ralph Nader and his likes in the 60s in the US. We had this new notion of product liability, right? Everybody believes, everybody feels, and rightly so, that if you introduce a product, you're responsible for for the harm that this product does, even if you don't have a contract with the consumer because you introduced that product on the market. That's called product liability. And you know what? That does not exist in the digital realm. You probably didn't think about that. And I only thought about it because of this case. It was a shocking realization, especially knowing that about 15% of all products are now sold over the internet. I'm talking about the intermediaries here like Amazon and the rest of them, and that these numbers are growing every second of the day. Product liability does not exist for digital products. Raises a lot of interesting questions in terms of 3D printing and the rest of it, We may have time for that during a Q&A, but let's get back to the point I want to make. Since product liability does not exist, the question as to who is responsible for misinformation, for manipulation, for bias in terms of education on the internet. These are key questions. Because we, again, are leaving the future of the universe that our children will build, the perception that they will have of everything, their interaction with their friends, with everybody. We are leaving that in the hands of these corporations, because this is where they'll get their information from. This is the philosopher's stone. This is their source of wisdom, not their parents and not their teachers, because the teachers should only make them aware of what I just said. We need to develop a base of accountability. I use accountability as a generic term, which covers product liability, but more than that. We need to make sure that if you sell or give away for free, and again, that doesn't exist, products on the internet, and especially when it comes to our children and their future, you're liable, you're accountable. That, of course, brings us to the question of how does that work? Do we need to certify and that kind of thing? All these very, very, very complicated questions. But the first thing is that if you want to enter into this realm, you are accountable for everything that may be hurtful as a consequence. Now, this is a key question, which is not only legal, but it's also very philosophical. And I think that one of the things that unfortunately we see happening because of this thing is that the notion of personal accountability is slowly withering away. It's a very, very unfortunate trend. It seems that opinions and judgments today are all made by political correctness. And that political correctness comes from what we read on this machine. Having your own point of view, defending that and standing up has always been a challenge, but now it's even worse. Because now it's really the whole world against you. And standing up for what you believe is almost suicidal today. You'll be shamed by everybody on the internet. Now, we know through history that what one man or one woman may know may be the truth. And we'll discover that 100 years later. I'm just very, very, very afraid that in this day and age of information, disinformation is going to win the battle. And standing up for your beliefs and being accountable for that is something that you as teachers, unfortunately there are only 3 or 4 of you in the room, this is your main obligation. Make sure that our children are really irritating, that they question everything, that they be trained from the first day at school to debate, to defend the opposite position, to develop this esprit critique. That's the critical skill. That's the essential skill. And the rest will flow from that. 3 seconds, that was pretty good timing, wasn't it? So, I hope that you survived this one, and look forward to the Q&As. Thank you. Thank you. So who's going to start?
Hey, can we get to the point of the school books? We already talked about the books.
Where are you?
Hello.
Over there.
Hello. You're talking about the corporations in the digital world. So what do you see as the main difference between corporations like Pearson or any other large textbook publisher who already dominates what kind of information we deliver to children? What's the difference or the main things that make this so concerning versus the existing situation?
Well, you're very right. I think that the short answer to a complicated question is concentration and monopolization.
Right.
And the effect, the pervasive, I didn't say perverse, but I was thinking perverse, the pervasive effect of this machine. I mean, she will go to bed with it, it'll be with her all the time, and it'll be a reflex, and that's the problem. I mean, how often have we not been at dinner parties when people check out stuff on the internet, and it's as if what they see there is the truth. If they want to win an argument, they say they read it on Wikipedia, right? Nonsense, complete nonsense. Well, I think that is a degree that's more than the textbook.
So my question is that in that case that you mentioned,
What?
in the case that you mentioned where someone was bloating and a spyware in the app,
Yeah.
and you said that apps, digital apps and softwares are not have a product liability,
Yeah.
but the networks, in that case Vodafone, have a network liability, and when they are using as a default app in their phone, does not that make them wrong there, and they are liable as well? So we can go back to Vodafone and say that you should not have at least made that a default app.
That was part of the case. You're absolutely right. That was absolutely part of the case. As I mentioned, SFR and Vodafone, and that was one of the real reasons why the case was settled. Now, two more words on that. The real problem here is, and bear with me because it's going to take a couple of minutes, the real problem here is that the law today, especially in the US, right, and since the US governs the internet, because that's a fact, whether we like it or not, is that these telecom providers and the internet service providers and the platforms and the search engines and the social media and so on and so forth are deemed to be what we call mere conduits, right? You probably heard about that. So once you're a mere conduit, which the telecoms are in terms of content, not the service, but the content, then they have absolute immunity. That's the rule under the Communications Decency Act. If you want to look it up, it's Section 230 from 1996. In Europe, I'll get to your question. In Europe, we have a different approach, which we call relative immunity. It's based on the e-commerce directive from the year 2000. But unfortunately, it has very little impact because it's really American law that applies.
Hello, sir. I have a question that are we heading towards intelligence divide while trying to bridging the gap for digital divide?
The intelligence divide.
Yeah, because we see our generation has learned a lot by doing lots of activities, and this next generation is already using all these technologies. So they don't know how it all happened actually, and they are directly using the AI and all these things. You ask a question to Google Assistant that which song is playing, so it will identify you for that. So are we actually heading towards a kind of an intelligence divide, that next generation may be a kind of a dumb generation?
Well, I think that you're perfectly right. And the thing is that the more quote unquote information we get, the less wisdom we have. And that is the point. And that is one of the things that maybe you're getting to a wisdom divide. Maybe that is the point you're making. And if that is the case, I totally agree. Yeah. Well, our teachers have that role to play. And again, you the teachers, unfortunately, there are only 3 or 4 of you in the room. I mean, you are really the soldiers protecting our values. You should be the civil service that has the most prestige and the best paid in any country. Really, I think that the teachers' union who are here, you probably all agree. You should be. The future is in your hands. But just beware. Don't fall into this trap of using this tool because you're already using it quite a bit. And by the way, fantastic. I think that you haven't really looked at your phone for the past at least 2 minutes. That's great. It's not that hard. Don't fall into the trap simply to say that innovation is a good thing. I was at a conference, the Global Forum conference last week, took place in Copenhagen. And the city of Copenhagen, they're so proud of having all this innovation, turning the city of Copenhagen into what they call a smart city, and of course what I call a surveillance city. And so they had this, they developed all sorts of devices for the cashless society, right? the cashless society. I just ask myself, why is the cashless society a good thing? Why? You know, can you imagine Saturday evening, right? Your pipes bust in your kitchen. How do you get a plumber to come if you don't pay him cash? You know what I mean? Doesn't work. Doesn't work. So it's as if innovation in itself is a religion. It's new, ergo it's good. That's nonsense. Innovation caused global warming. Innovation causes cancerous diseases. Innovation created a nuclear bomb. Let's get away from this religion that innovation is good in itself. It's not.
I have a question. What do you think about, do you think that the oral narration has an edge over the technology?
Sorry?
What are your opinions about the oral narration? Does it has an edge over the technology, the digital technology, right? The oral narration.
The correlation.
The oral narration
The or-
to the children. Do you think that it has an edge over in today's digital world?
I'm sorry, I didn't.
Like, do you think oral narration has an edge over technology in the context in which you are talking to make sure that the children are irritating and make sure they engage in debates? So do you think when teachers are more into oral narration, they're more talkative with the children,
Got it.
do you think it has an edge over technology? It's better than technology?
Absolutely. Absolutely. No, sorry, I didn't understand your question. I really didn't want to be rude. But yes, absolutely. And it goes back to the point of debating, right? And it's really, to me, it's a lost art. It's a lost art. As I said, that innovation is not an end in itself. That's, I'll stand up and defend that anytime you want. But an art, l'art pour l'art, as we say in French, the art for its own sake, is really debating. We could learn a lot from the ancient Greeks, and we should really not forget that all that wisdom is there already. We just have to look for it and find it and get it introduced in the schoolrooms, in the classrooms. But again, when you're 5 years old, when you're 6 years old, you're clever enough to learn the art of debating. And that will create the essential skill, which again is the subject of my presentation, which is that of questioning everything. Because again, otherwise we'll all be turned into robots. You have a question?
I have a question. It kind of follows on from what Jeffrey had mentioned earlier. Is a lot of these products in the long 11-page list of conditions, they suggest a certain jurisdiction where it's going to be resolved. But the issue is now so transboundary that is there a need for some new international resolution process, that it's not within this California state, well, it's not within the US state, but it goes, well, what we have right now is the International Criminal Court, but that's just focus on the criminal acts. Is that something that is necessary to address this particular issue? Because with AI now emerging, the power of AI depends on getting as much data from across the world. Yeah. Not just one particular part, because then you get confined.
You just identified one of the major problems we have on the internet from a legal point of view, the universality of the internet pitted against sovereign laws. And how do we deal with that? Now, I happen to be part of a working group headed up by the Special Rapporteur on Privacy by the United Nations. And what we're working on is trying to define the national security exemption to data privacy. Read Snowden, all right? Data privacy, even in the GDPR in Europe, has exemptions when it comes to national security. Now, how do we define national security? And how do we make sure that that definition is not being abused so that whenever the government wants information, it just says national security? And what kind of legal procedures do we have? Do we need like a FISA court that we have in the US at an international level and so on and so forth? Now that led us, in a special working group, to think about what we call an online dispute resolution mechanism. It really started off with defamation. As I said before, today the opinions and the judgments made by the public, by the wolf pack, causes people not only not to stand up for their convictions because they're going to be shamed, but also causes people to lose their reputation because of defamation. It's more or less the same thing, that everybody gets together in attacking someone and he doesn't stand up for his convictions. That's why, and that's universal. I mean, it doesn't help getting something taken down in India or in France or in Denmark or in the UK if you can still access it on a domain name .com. That's really your question. By the way, we're all waiting for a decision coming down, hopefully in February, from the European Court of Justice on that particular question relative to Europe, the US. It's called the global reach problem. But what we're working on in this UN subgroup is an online dispute resolution mechanism which will allow swift, because that's really the key. The damage is done immediately on the internet. And what's up there remains accessible in principle forever. So the damage is immediate, and it's viral, and it's there forever. So if you want to do something about that damage, speed is essential. That is why the normal legal system, whether it's arbitration or whatever conflict resolution scheme you have, simply doesn't work. You're so right. We need an online dispute resolution mechanism which all countries can agree on based on shared values. Now, this is going to be very complicated because we'll have a lot of values that are not shared, but there are quite a few that are shared by the whole international community. Suffice it to refer to the Universal Declaration of Human Rights from 1948. Each and every member of the United Nations has de facto adopted that Universal Declaration of Human Rights, which contains some 30-odd rights. Most countries have signed up to the International Covenant for Civil and Political Rights, the ICCPR, which has more details about that and also has a dispute resolution mechanism, but again, that one doesn't work. So what we should be working towards is defining or implementing those rights on which we all agree, and we'll find most of them in the Universal Declaration, and then have an international dispute resolution mechanism that will apply these rights to the impugned content before them. Maybe wishful thinking, but it's necessary. It's necessary if you want to maintain an internet that's universal. And that's kind of like the idea of the internet, right? This global empowerment and all these wonderful buzzwords. It really rests upon the presumption that it's universal, that we all get the same information. That's the idea. If we don't do anything about the problem that you just asked, the question you just asked, that universality of the internet is going to disappear. And what we usually say when we do policy on that is that the internet will become the splinternet. And that will also aggravate the problem of the digital divide or the misinformation, which you already see with certain countries that are not really part of that universality. We have some delegates from China, you know what I'm talking about. That country took a conscious decision of having its own internet, so to speak, with a great firewall. Do we want that all over the world? We probably don't, but it's going to happen if we don't get that dispute resolution, absolutely.
Okay. Thank you very much for a very good presentation. Why it really comes home to me is because, like Maya, I have a 2.5-year-old girl, and she fights with me on the phone that it's my phone. And I've started to look at it, I'm kind of like, pretty a bit confused when it comes to regulating that or access to, because now, even while I'm not around, she could actually have access to a phone, perhaps through her mom or something like that. So in unregulated societies, I came in from Nigeria, and we don't really have strong cyber laws and all that. And So talking about things like digital and online things, it's a challenge. How do one regulate that for a kid growing up and maintain a kind of a confine for the child to kind of like, like grow up to like 5 or 6 to be able to be critical enough to know this is not the right thing, this is not appropriate, and this is what I should do. I need you to help me out.
It is a real problem. In France, what we did, very recent law, is that we really prohibited the use of cell phones at school. And everybody really agreed that that was a good idea. It allowed the teachers to get the necessary attention, and it also allowed the children, at least while they're at school, not to grow more and more dependent upon this special tool that becomes part of their anatomy. But of course, there is a life outside of school, and I really think that the only solution that we have is we can't prohibit our children from using this. It won't work. They'll become asocial. I mean, the peers do it, and if they don't follow what's going on already today on YouTube or whatever, they didn't pick up the latest acronyms, they'll become autistic. So it's a question of their whole existence and their way to function in social life. So we can't say you can't use the phone. But what we can do, and it's the only thing is to make them understand that most probably the information they get there is wrong. I would like them to believe it's wrong as the point of intellectual departure, rather than the opposite. It is wrong, it is wrong, it is wrong. Check it, check it, check it. You are now under an obligation to defend the opposite point of view. Connecting the dots, that's another problem. Since information is accessible, I use information here as a generic term, immediately, as I mentioned before, there's no reason to read and write and math and know anything at all because you just get it. Your memory, you don't need it anymore, right? So you won't be able to connect the dots any longer. You won't be able to go back and compare what happened with the ancient Greeks and so on. Because, if you ever heard of them, it was like a nanosecond when you happened to skip by a page and you wanted to look up something with PL and you happened to enter Plato and you were looking for Plato, and then that's the kind of thing. You need to be able to connect the dots. You need to be able to get that esprit critique if you want to function. And it's really, once again, there's only one core of democracy that can help us attain that. It's not the parents. They're too busy. Her mother, whom I met, parents are divorced. Mother works, very tough day. She comes home. This is the babysitter, all right? This is the babysitter. And that's the danger. So really, education, to me, is not really a question of learning through the internet. It is the opposite. It is the opposite. It is selecting the information and always being critical of it and getting the global view of this universe, which is dramatically changing, a universe where people marry holograms. Just think of that. I'm not inventing it. You can look it up in the news.
Ladies and gentlemen, sorry to interrupt the questions. I'm sure we can go on, and this is a very fascinating session, but we really need to move on with the rest of the schedule. So first of all, I'd like you to thank Dan Schaffer for this wonderful talk. It was an excellent interactive session.
Thank you.
And that brings us to the end of the morning session. Please also give a huge round of applause for both speakers, Dan Schaffer and Jeffery Morrison, for shedding some light on the topic and for encouraging some very thought-provoking questions. Thank you so much. Just a few quick questions before we break. First of all, to all delegates, to show your support on the WISAC Declaration, I'd like you to visit our website and click on the thumbs up or like on the specific document. Also, to keep yourself updated with the latest schedule, conference documents, and speaker lists, whoever hasn't done it already, please download the Tech 2018 guidebook app. Tweet at the Tweet Cafe to win goodies and merchandise. Create new beats at the Mash Machine. And for all those interested to sign up for the Vizag City Tour, please do so today and join us for the cultural evening also in the evening. Tweet with hashtag Tech2018 and tag us to win the HP Elite Book 820 and follow us on social media. Change of plan. Yeah, there isn't a cultural evening tonight. We'll be breaking for the city tours in the evening. We'll now break for the breakout sessions, which will be beginning soon. So I'd like you to please kindly move out to the respective sessions that you're interested in. Yeah, thank you.